Now we will discuss on very important topic, corporate insolvency resolution process, CIRP. So the major points which we are going to cover on the introduction to CIRP, who can initiate CIRP, jurisdiction and what is the default amount, who are the key players in corporate insolvency resolution process, what is moratorium, what is resolution, who are the resolution professionals, and what is the resolution plan. So who can initiate CIRP? And first we'll come from introduction. CIRP stands for Corporate Insolvency Resolution Process. CIRP means Corporate Insolvency Resolution Process. It is governed by the Insolvency Bankruptcy Code, that is IBC 2016. The process aims to resolve corporate insolvency efficiently. Who can initiate CIRP? CIRP can be initiated either by financial creditor or by operational creditor or by corporate applicant by itself. So, CIRP can be initiated by financial creditor under Section 7 of IBC, that is lenders and banks. Lenders and banks can initiate under Section 7 of IBC. And operational creditors can initiate CIRP under Section 9. Who are operational creditors? Suppliers, employees, or service providers. Then corporate applicant can initiate CIRP under Section 10. That is, corporate debtor itself can initiate under Section 10. Then what is the jurisdiction and what is the default amount? The jurisdiction, corporate insolvency resolution process cases are handled by Honorable National Company Law Tribunal, that is NCLT. The minimum default amount for initiating CIRP is 1 crore. Earlier it was 1 lakh. So in 2020, it is updated to 1 crore. So now the minimum default amount for initiating corporate insolvency resolution process is 1 crore. That is the minimum amount to approach NCLT under CIRP. Who are the key players in CIRP? The financial creditors, operational creditors, resolution professional, committee of creditors. Financial creditors, either a person or entity owed financial debt. Operational creditor, a person or entity owed operational dues. Operational dues are either supplies, goods, services, salaries. These dues related to the goods supplies and related to the services, related to the employment, salaries. Resolution professional. This resolution professional manages the entire CIRP process. Committee of creditors. It is formed with the financial creditors. Makes a key decisions on behalf of creditors. Where there are no financial creditors, then operational creditors will come into the picture. These are the key players: financial creditors, operational creditors, resolution professional, and a committee of creditors. What is a moratorium and what is a resolution? Moratorium, it is a legal suspension of debt recovery actions and lawsuits against the corporate debtor. So, moratorium is the suspension of debt recovery actions and lawsuits against the corporate debtor during the process. It is declared by Honorable NCLT when CIRP begins. Once the CIRP admits, then NCLT declares moratorium. This moratorium ensures smooth functioning of corporate insolvency resolution process without external legal actions. So, hence the resolution plan is approved. So, then there is no resolution plan. Then liquidation begins. Resolution professional and resolution plan. The resolution professional takes over the management of the corporate debtor. Resolution professional prepares an information memorandum containing financial details, full details. Resolution professional invites the resolution plans from the eligible bidders. Of course, section 29A restrictions has to be taken care. The best plan will be selected and approved by the committee of creditors. So, voting rights and decision making. Committee of creditors COC votes on resolution plans. The minimum required voting is a 66% to approve the resolution plan. 66% majority required for approval of a resolution plan. The other matters requires 51% majority votes, whereas 66% is required minimum for, this is for approval of resolution plan. Approved plan will be submitted to NCLT for final approval. Once the plan is approved by COC, then it will be submitted to Honorable NCLT for final approval. So what are the timelines and completion? CIRP must be completed within 180 days. It is extendable by 90 days with the approval of COC and the Honorable NCLT approval. So it is 270 days. If any legal matters involved, then the maximum is 330 days. If no resolution is approved, no plan is approved by COC within the time frame, then what is next course? Then the corporate debtor will be sent to the liquidation. If no resolution plan is approved, then it will go into the liquidation. What is the liquidation process? If no resolution plan is approved, then the corporate debtor goes into the liquidation. The liquidator is appointed to sell the assets and distribute the proceeds to the creditors. Order of priority in distribution is first CIRP costs or liquidation expenses will be taken care. Then secured creditors and workman dues. Then unsecured creditors. Then government dues. Then equity shareholders, if anything remains. This is the order of priority in distribution. Appeals and legal recourse. CIRP decisions can be appealed. The National Company Law Appellate Tribunal, NCLT, hears appeals from NCLT. From NCLT, then can be approached to Honorable National Company Law Appellate Tribunal, NCLT. From National Company Law Appellate Tribunal can be appealed to Supreme Court when the matter of law is involved. Ensures fairness and compliance with the IBC provisions. Thank you. Hope you are clear on IBC.